Welcome to the presentation on the Medicaid Application and Addendum for justice-involved individuals. This presentation will address the following key topics: how to complete the Medicaid application and the Medicaid Addendum for justice-involved individuals, review of the eligibility requirements for justice-involved individuals, review of the application and addendum submission timeframe. The Medicaid application for justice-involved individuals must be completed by those applying for medical assistance through Medicaid or Nevada checkup while currently incarcerated. Eligibility for Medicaid and/or NCU will first be assessed under an available reentry program. Juveniles can be potentially eligible for pre-release services starting 30 days prior to their release date and for at least 30 days following their release. Applications for assistance may be submitted up to 120 days before the scheduled release date. Individuals who do not qualify for a reentry program may still be considered for placement in a Medicaid NCU suspended status if they meet all other eligibility criteria. Individuals who do not qualify for Medicaid NCU will receive a denial notice. Let us now review the Medicaid application process for individuals involved in the justice system. On the initial page of the application, you will find the criteria for determining eligibility for the reentry Medicaid coverage and suspended Medicaid programs. Before completing the application, please verify if the individual qualifies for either the reentry Medicaid coverage or the suspended Medicaid programs. Carceral facilities must confirm that the individual meets these requirements by submitting a completed DWSS Form 2971, Justice-Involved Medicaid Transition Request, to DWSS. Juveniles who meet the eligibility requirements for release may qualify for the reentry program, which provides assistance starting 30 days before their release date. The requirements for the 30-day pre-release for juveniles encompass both non-financial and financial eligibility factors. We will explore these factors in greater detail during the training session. The age criteria for juveniles extend up to 19 years old. Juveniles aged 19 and 20 may qualify for childless adult eligibility, and former foster care youth up to age 26. Please note if the individual is ineligible for reentry services but wishes to apply for suspended Medicaid, they may complete and submit the same application. If they meet all the financial and non-financial eligibility criteria, their Medicaid will be approved in a suspended status until their verified release date. When assisting the applicant with the application process, ensure that all available information is entered accurately. Let us begin with the applicant information field. The applicant or authorized representative must provide the inmate's full legal name, date of birth, incarceration status, and the expected release date of the incarcerated youth. Next, enter the facility name and address, including the physical location of where the incarcerated youth is housed. Provide a mailing address, which can be that of the facility or the applicant's choice. The applicant may also enter a contact number for the facility or another number of their choice, including a secondary number if available. Enter the language of the inmate if their preferred language is other than English, and designate if an interpreter is needed. Provide an email address, which can be that of the facility or the applicant's choice if available. DWSS requires the Social Security number or tax identification number of the incarcerated youth. Provide the inmate's marital status, pregnancy status, gender, and lastly, attest to whether or not the inmate is legally blind or permanently disabled. The following section of the application addresses the tax filing status of the applicant. The incarcerated youth must indicate whether they will be filing taxes or will be claimed as a dependent in the upcoming year. In the example provided, the applicant has stated that they will be claimed as a dependent by their parent. To be potentially eligible for medical assistance, an applicant must be either a United States citizen or a qualified non-citizen. If the applicant is a qualified non-citizen, they must specify their category, such as a legal permanent resident, an asylee, a refugee, and so forth, and provide their alien number in the identification number field. The following question inquires about military service for the applicant's spouse, domestic partner, and/or parent. This information is necessary to assess whether the applicant may be eligible for military benefits. In the Current Income Information section, the applicant must confirm all sources of income they are receiving. This includes any funds received by the inmate for commissary purchases. If the applicant has any source of income, they must specify the type of income, the gross amount received, and the frequency of that income on the application. The eligibility team will request verification of the reported income to assess the applicant's potential eligibility for medical assistance. We will now review the race and ethnicity of the incarcerated youth. Applicants who identify as American Indian or Alaskan Native and become eligible for Medicaid or Silver State Health Insurance can also receive Indian and tribal health services. Please ask the applicant to indicate if they are American Indian or Alaskan Native. If applicable, they must provide their tribal affiliation. If the applicant identifies as Hispanic, Latino, or of Spanish origin, please have them indicate their specific Hispanic heritage. Although optional, applicants are allowed to identify their race. In the Health Insurance Information section, the applicant must confirm whether they currently have health insurance, as Medicaid is the payer of last resort. If applicable, the applicant must specify the type and name of the health insurance they are currently receiving. DWSS is committed to non-discrimination. In accordance with federal law, discrimination based on race, color, national origin, sex, age, sexual orientation, gender identity, or disability is strictly prohibited. Applicants are encouraged to report any incidents of discrimination. Complaints can be filed online, by mail, by phone, or via email. In the following 3 sections, we will cover essential information about Medicaid assistance. The Medicaid Estate Recovery Program applies to Medicaid recipients aged 55 and older, as well as those who are inpatients of a medical facility. These individuals may be required to repay Medicaid expenses incurred on their behalf. The recovery of these payments will be sought from the recipient's estate after their death or the death of their surviving spouse. Third-party liability is a crucial eligibility requirement for receiving Medicaid benefits. Applicants must understand that if anyone listed on this application receives Medicaid benefits, they grant the Medicaid agency the authority to pursue and collect any funds from other health insurance, legal settlements, or any other third parties that may be liable for the medical services covered by Medicaid. This includes the right for Medicaid to seek child and medical support from a spouse or parent. Additionally, applicants must agree to cooperate and provide information regarding any legal settlements or legal actions to the Medicaid agency to facilitate the recovery of funds from third-party sources. The Department of Health and Human Services, DHHS, reserves the right to review and investigate all information submitted in the application. Applicants should understand that by applying, they authorize DHHS to conduct investigations regarding themselves, other household members, and the legal or natural parents of the applicant's children as necessary to assess eligibility for benefits. The information provided may be verified by federal, state, and local officials, including quality control staff. Applicants must comply with these terms to be considered for benefits and to maintain them after approval. Any failure to cooperate or provision of false information may lead to repayment obligations and potential criminal prosecution. The DHHS, Department of Health and Human Services privacy policy, mandates the protection of your information by law. The details submitted in your application will solely be utilized to assess your eligibility for medical health coverage. DHHS will access information through electronic databases from state and federal agencies, including the Internal Revenue Service and the Department of Homeland Security, as well as other consumer reporting agencies. This information is essential for determining your medical eligibility. If there is a discrepancy between the information you provide and that obtained from our electronic databases, you will be required to submit additional information to resolve the conflict. Understanding this policy and granting your consent will facilitate your eligibility determination without unnecessary delays. The Department of Health and Human Services, DHHS, offers an optional text messaging system. This system enables your assigned managed care organization, MCO, to inform you about important information related to your healthcare needs and treatment, wellness services, plan benefits, eligibility, renewal, and redetermination. Additionally, it facilitates other communications regarding your relationship with DHHS or the MCO concerning your health coverage. You may receive calls and texts from both automated technology and customer service representatives. Please note that standard message and data rates may apply. The Health Plan Selection section outlines the coverage options available for individuals residing in urban Washoe and Clark counties under a managed care organization, MCO. Incarcerated youth will have the opportunity to select one of 4 MCO plans specifically available to residents of these urban areas. The available options for healthcare coverage are Anthem Blue Cross and Blue Shield, Molina Healthcare, Silver Summit Health Plan, and United Healthcare Health Plan of Nevada. Inmates living in rural areas outside of Washoe and Clark counties will continue to receive the Medicaid Fee-for-Service Plan, commonly referred to as straight Medicaid. If no selection is made, a random algorithm will assign an MCO plan. It is important to note that choosing a plan does not guarantee enrollment in the Nevada Medicaid or Nevada Checkup programs. Additionally, if the inmate or any household members are already enrolled in a specific MCO plan, they may be restricted from switching to another plan. Upon approval, incarcerated youth will receive further details from the MCO plan through a member handbook. The incarcerated youth or their authorized representative has the right to ensure the accuracy of the application determination. If the applicant believes there has been an error in the medical determination, they have the right to appeal and can request a re-evaluation of their medical case. Additionally, the incarcerated youth or their authorized representative is responsible for reporting any changes during the approval period. All changes must be reported by the 5th day of the following month. Applicants should be aware that any reported changes may affect their current eligibility status. The applicant must provide authorization for the release of information to the Department of Health and Human Services. Additionally, the applicant must release the information holder from any liability that may arise from the disclosure of the required information. If the applicant is over the age of 18, they are required to sign and date the application. This step is essential for validating the information provided, as it serves as an attestation from the incarcerated youth or their authorized representative. If the applicant cannot sign due to an inability to read, write, or being blind, a witness must provide their signature and date. This witness should have read the application information to the applicant and observed the applicant's signature or marking. Finally, on page 4 of the application, this section outlines where to submit the application and any supporting documents. It is essential to ensure that the applicant and/or authorized representative signs the application. A disclaimer notice has been included to inform the incarcerated youth or authorized representative that upon release from the public institution, they must provide their intended residence address. This requirement ensures that important documents, Medicaid cards, and any additional information are sent to the correct address. Individuals who are 17 years old or younger are not permitted to sign the application themselves. For a minor child aged 17 or younger, when a parent or guardian is not available to sign and submit an application on behalf of the minor child who is incarcerated, the carceral facility has the authority to complete and submit the application and designation of authorized representative form on behalf of the minor. The Statement of Designated Representative section is to be completed by the designated carceral facility staff member with their name, position, title, and date. All facility information, including address and telephone number, must be provided. If an individual aged 18 and over designates an authorized representative who is not present at the time of application, a designation of authorized representative form 2525 will be sent by the DWSS staff member. This form must be completed by the designated authorized representative. The designated authorized representative is required to provide their contact information and signature to confirm their agreement to act as the incarcerated youth's authorized representative. This process does not stop the application process. However, in order for the designated authorized representative to be valid, the form must be returned to DWSS as soon as received. When the applicant is aged 18 or older and wishes to appoint an authorized representative, they must also complete the designated section of the application. This includes marking yes and providing the name, contact information, and address of the authorized representative. The applicant must then sign and date the application to confirm their selection. As previously mentioned, an applicant aged 17 or under must have a designated authorized representative to apply on their behalf. If no parent or guardian is available at the time of application, the carceral facility may apply on behalf of the applicant and designate themselves as the authorized representative for the juvenile. On the second portion of the form, Designation of Authorized Representative, is the designation of the facility section. This section outlines the criteria for designating the facility as the representative. This facility designation should be completed under the following circumstances. A. When the incarcerated youth is 17 years old or younger and has no available guardian or parent, the facility will be designated as the representative and will complete all section fields, as the carceral facility has the authority to complete and submit the application and designation of authorized representative form on behalf of the minor. Or B. When the inmate is 18 years old or older and has chosen to designate the facility as their representative. If the applicant inmate aged 18 and over wishes to designate the facility as their authorized representative, both the applicant and the facility staff member must complete and sign these sections. The incarcerated youth aged 18 or older will print their name, facility name, and then confirm their authorization of the facility as either the primary or secondary representative by signing, along with their birth date and the date of signing. A staff member from the facility will then indicate their agreement to serve as either the primary or secondary representative by signing and printing their name. They will also provide their position, the date of signing, the facility's location, contact number, and the name of the facility. Upon the release of an incarcerated youth from the facility will cease to be the authorized representative of the applicant. The justice-involved application, Addendum Attestation of Eligibility for Reentry Program Form 2971 must be completed by the carceral facility or their authorized signatory healthcare professional as an addendum to the Medicaid Application for Justice-Involved Individuals Form 2970. This form serves as an attestation from the carceral facility, signatory, or healthcare professional regarding the inmate's eligibility for a reentry program. It confirms whether the inmate qualifies for the program based on the criteria specified in NRS 422.272428. If an inmate was initially eligible for reentry but becomes ineligible due to unforeseen circumstances, this form is utilized to suspend the Medicaid assistance that was approved 30 days prior to their release date up to 120 days after the reentry approval. The 2971 must be utilized each time a request for the reentry program or to suspend Medicaid. Let us now review the Medicaid addendum process for individuals involved in the justice system. The justice-involved application. Addendum Attestation of Eligibility for Reentry Program. Form 2971 must be completed with each application submission. Additionally, if an applicant is currently receiving Reentry Medicaid assistance and their original release date has been extended, or if other circumstances arise that affect eligibility, Form 2971 must be submitted to suspend the current Medicaid eligibility. The facility staff member will provide the juvenile's legal last and first name. Enter the juvenile's Social Security number or tax identification number. List the juvenile's date of birth and gender. If available, provide the inmate's Medicaid billing number. Enter the current address of the inmate. Indicate the inmate's current Medicaid status by selecting one of the following options: none, suspended, or unknown. Facility medical staff should have access to the eligibility verification system to verify if an applicant is currently receiving Medicaid. In the second section of the addendum, the authorized signatory and/or healthcare professional will attest to the inmate's eligibility for the Reentry Program or request the suspension of current Reentry Medicaid eligibility. They must provide the release date of the incarcerated youth. It is important to note that when an incarcerated youth qualifies for the Reentry Program, they can receive pre-release services 30 days prior to their release date. An application can be submitted as early as 120 days before their release date. If circumstances change while the applicant is receiving the Reentry pre-release services while in their 30-day eligibility, and they become no longer eligible, and their release date has been extended, you can request that the medical assistance be placed in a suspended status by providing the effective date of suspension. Additionally, if the release date is shortened due to an early release, this form must be submitted showing the new release date. For example, if we submit an application on February 1, 2025, for an incarcerated youth set to be released on April 1, 2025, DWSS receives the application, addendum, and all required verifications to process the inmate. The incarcerated youth becomes eligible for the Reentry Program on March 1, 2025, to receive their 30 days of pre-release services while incarcerated. On March 5, 2025, the incarcerated youth's circumstances have changed, and their release date is now pushed to November 1, 2025. Submit another Form 2971 to request the incarcerated juvenile be returned to a suspended Medicaid status effective April 1, 2025. Finally, in Section 3, the authorized signatory and/or healthcare professional must print their name, title, and NPI number. They are required to sign and date the addendum, as well as provide the facility's address and contact information. As outlined in the review of the application process, if an individual aged 18 and over designates an authorized representative who is not present at the time of application, a designation of authorized representative Form 2525 will need to be signed by the applicant and all applicable information completed. A form will be sent to the indicated authorized representative's address to complete the process. This form will be sent by DWSS staff. Again, as outlined in the review of the application process, when the applicant is aged 18 or older and wishes to appoint an authorized representative, they must also complete the designated section of the application. For a minor child aged 17 or younger, when a parent or guardian is not available to sign and submit an application on behalf of the minor child who is incarcerated, the carceral facility has the authority to complete and submit the application and designation of authorized representative form on behalf of the minor. Please follow the same steps when completing the facility designation for the authorized representative section of the addendum. If the individual is over 18, they will provide their birth date and sign and date the form. Next, indicate if the facility will be a primary or secondary representative. Please note, if the individual is under the age of 17, the facility will complete this section. A staff member from the facility will then indicate their agreement to serve as either the primary or secondary representative by signing and printing their name. They will also provide their position, the date of signing, the facility's location, contact number, and the name of the facility. Upon the release of an incarcerated youth from the facility will cease to be the authorized representative of the applicant. Once you have completed the application and addendum in full, please scan and attach them along with any supporting documents to JusticeMed at dwss.nv.gov. Ensure that you include application submission in the subject line. Alternatively, you may fax the documents to 702-631-3387. If you need immediate virtual assistance, please include Justice-Involved Assistance Request in the subject line of your email to ensure proper vetting. For returning requested verifications or additional documents for the inmate, please use Verification Submission in the subject line, as well as ensuring the inmate's name and case ID from the corresponding insufficient information form are included in the body of the email and all documents are attached. This will help us prioritize emails effectively. It is essential to complete both the application and addendum thoroughly to ensure a valid submission. If any information, such as demographic details, contact information, or signatures, is missing or invalid, the application may be returned to the facility, causing delays in processing time. Upon submission of a valid application and addendum, certain information may necessitate a request for verifications. An insufficient information form 2429 will be sent to the provided mailing address. Verifications must be submitted by the due date listed on the insufficient information form. The incarcerated youth may use the facility address for mailing to expedite the verification process to DWSS. Effective communication among the facility, the inmate, and the parent or guardian is essential. It is crucial to provide daily updates on the release dates of upcoming inmates. Any changes regarding release dates, income, household composition, address, and similar matters must be reported by the 5th of the following month. However, reporting this information sooner will expedite the case review process. Facility staff and/or the parent or guardian can use Form 2584 to report these changes. It is vital that once the incarcerated youth is released, both the inmate and the authorized representative report the current mailing address. This is necessary for issuing a new Medicaid card, a new notice of decision letter, and any other important healthcare information. You can find this form on the DHCFP website in the Justice-Involved Reentry section, alongside other applications and forms. Now that we have thoroughly reviewed the application and addendum for justice-involved individuals, let's go over some important reminders. 1. The Reentry Program provides pre-release services to incarcerated youth 30 days prior to their release date and 30 days following their release. 2. Suspended Medicaid is applicable when incarcerated youths are receiving medical assistance, but their circumstances have changed, necessitating a suspension of their current Medicaid eligibility. 3. The Justice-Involved Application Addendum. Attestation of Eligibility for Reentry Program Form 2971 must accompany every application for the Reentry Program, as well as whenever there is a change in an incarcerated youth's current reentry status or suspended Medicaid status. 4. Ensure that the application and addendum are fully completed. 5. Ensure that any juvenile minor applicant aged 17 and under has a designated authorized representative who can apply and designate themselves as the authorized representative on behalf of the juvenile minor applicant. 6. If any incarcerated youth aged 18 or older designates an authorized representative other than their current facility, the designated individual must complete the designation of an authorized representative Form 2525EE, which must be signed by both the inmate and the representative. 7. When submitting an application, documents, or requesting information that you utilize the email JusticeMed at dwss.nv.gov or fax number 702-631-3387. 8. If further information is needed to process the application and addendum, the Insufficient Information Form 2429 will be issued. Verifications must be submitted by the due date listed on the Insufficient Information Form. 9. Finally, any changes that occur after the application and addendum process has been completed, the submission of Change Report Form 2584-EG will be required. This form must be submitted by the facility if the change happens while the inmate is currently housed, or by the juvenile minor's parent guardian, authorized representative, and/or by the incarcerated youth aged 18 and older, along with their designated authorized representative if applicable. Thank you for viewing this presentation. For further information, please email justicemed@dwss.nv.gov.